Well, good afternoon, everyone. Welcome and thank you for joining us. My name is Drea Schmidt. I am a partner in the business department at Tonkon Torp in Portland, Oregon. And I am joined this afternoon by my colleagues Betsy Judd and Ferdie Ruplin. So before we get started with our program, I want to pause and make just a few notes about our format. First, we are recording this webinar. You don't need to sign any kind of disclosure, and none of your private information is going to be shared. But do be aware that if you decide to participate in our Q&A section, your question could be recorded in association with your name. We won't use your name on the webinar, but your question would be recorded in connection with your name. So feel free to submit your questions in the Q&A section of your Zoom app, and I will do my best to get to as many of the questions as we can. Because the PPP situation continues to change, we may not know all the answers, or your questions might be too nuanced or specific for us to answer in this webinar format. But we do welcome you to reach out to any one of us directly or to the Tonkon Torp attorney that you usually work with. We also welcome any feedback that you have after this webinar. If there are specific aspects, specific PPP topics that you want to hear more about, tell us about it. We do plan to do some more webinars in the future. At least one more is coming up in this series. So let us know if there's anything specific that you'd like to hear about. And lastly, the information that we are going to be presenting here today is as of today, June 30th, 2020. I think everyone knows that the PPP landscape continues to change quickly. So that is not intended to be legal advice, and it is accurate as of today. So let's get to the meat of our program today. I think as everyone that is attending this program doubtless knows, navigating the PPP has been a pretty frustrating and dizzying process for borrowers, with constantly changing rules and deadlines. In normal times, Ferdie and Betsy and we practice general business law, and we help our clients address a broad spectrum of legal issues. But in recent months, we've ended up just really becoming experts on the PPP, as this has become a really key issue for many of our clients and friends. As challenging as this whole process has been, we hope that we have been and can continue to be a source of information for our business community throughout this time. So now, finally, I think we have some good news. We are starting to see Congress and the SBA loosen some of the restrictions on PPP loans. They are giving borrowers more time to use the funds, more flexibility in what funds can actually be used for, and finally streamlining the forgiveness process. And we're starting to get answers to many of our questions. I think many of you will remember that we've done a lot of these webinars where we have more questions than we have answers, and we are starting to get some of those answers. So that is all really good news for borrowers. So today we're going to talk specifically about the new Easy Forgiveness application. We're going to talk about new guidance on when you can apply for forgiveness, as well as some of the reasons that you may want to consider applying sooner rather than later. And then we'll give you some of the answers to the questions that we've really been waiting on. At that point, we'll go ahead and turn things over to the Q&A. We're going to keep our presentation today to 45 minutes. We'll end at 2:45 p.m. so everyone can get back to business and start thinking about your upcoming holiday weekend. One last thing before we get into the roundtable, I do want to point you to the PPP webinar or the PPP resources that Tonkon has posted on our COVID-19 page at tonkon.com. On that page, you will find all of our recent webinars. Those are all recorded and there are links to those webinars, Q&As and summaries of the PPP, including recent summaries of the Flexibility Act and other PPP guidance. And so if this is the first time that you're tuning in, I encourage you to take a look at those resources. There will be answers to many of your questions already posted in the information that's there. So with that, I'm going to go ahead and dive in. Betsy, do you want to tell us a little bit about the new Easy Forgiveness application? How long is the application and how long is it expected to take to complete?
Sure, thanks Drea, and hi everybody. So on June 16, the SBA put out both an updated forgiveness application and the new Easy Forgiveness application. The Easy application is simpler, it's more streamlined than the long form forgiveness application. The long form application is a total of 11 pages, including instructions, and the Easy application is only 6 pages, including its instructions. And so the bulk of what's been cut out is Schedule A of the long form forgiveness application and the accompanying worksheet, which contains sort of the show your work section for your calculations for your FTE counts, wage levels, and so forth that would reduce your loan forgiveness. Because of this, the Easy application should take significantly less time to fill out than the long form application.
Great. So that definitely sounds like an improvement over the long form application that borrowers have seen previously, which I think has been pretty complicated and overwhelming for people. Can you talk a little bit about which borrowers are going to be eligible and be able to take advantage of the Easy application?
Sure. So the instructions to the Easy application lays out specifically who can use it. There's 3 categories of borrowers that are going to be able to take advantage of it. First are self-employed borrowers, individuals, independent contractors, sole proprietors that have no employees and didn't include any employees in computing their average monthly payroll for their PPP loan amount calculation. The second category of borrowers are borrowers who did not reduce annual salary or hourly wages of any employee by more than 25% during their covered period, and didn't reduce the number of employees or average paid hours of employees between January 1 and the end of their covered period. Reductions doesn't include reductions of individuals who were employees on February 15, 2020, if the borrower hired somebody to replace them, hired a similarly qualified individual before December 31st, 2020. And it also doesn't include reductions in employee hours where the borrower offered to restore those hours, but the employee turned them down. The third category of borrower that can use the Easy application are borrowers that did not reduce annual salary or hourly wages of any employee, again, by more than 25% during their covered period, and they were not able to operate during their covered period at the same level of business activity commensurate with their business activity level as of February 15, 2020, due to sanitation, social distancing, and worker or customary safety requirements related to COVID-19. So borrowers that want to use the Easy application have to certify that they meet one of these categories. So you'll want to maintain documentation just backing that up.
Okay, so there's a lot there, and it does sound like, given in particular the exceptions that you outlined for folks, that there are going to be quite a few borrowers who will be eligible to use the short form Easy application. and maybe particularly those who have been affected by shutdowns like restaurants and hotels. Do you think of any examples of specific situations where borrowers will not be able to use the EASY application?
Yeah, so it's really just those very specific 3 categories, and you really just have to check the box to be able to use it. So a business that doesn't meet one of those categories would be, for example, a business that had to let employees go and it didn't make financial sense to replace them or rehire them, or a business where, you know, their business activity has dropped off, but it can't be directly tied to government requirements related to COVID-19. So they can't take advantage of that last quarter category, for example.
Right. So you're saying, you know, there could be situations where folks have had a reduction in business activity just because they've had less business, but it's not a direct result of being ordered to shut down or not being able to operate, and those folks may not be able to take advantage of the EASY application.
That's right.
Okay, so the EASY application is posted on the SBA's website for anyone who wants to take a breeze through it, and it really is a breeze, and I encourage people to take a look at it. It's also included in a link in the Q&A on Tonkon.com that we put out on the EASY application. I think most of you will have received that Q&A via email, but it's also posted on our website. So shifting gears just a little bit, one of the consistent questions that we've been getting following the adoption of the 24-week covered period is whether borrowers would need to wait until the end of the 24-week period in order to apply for forgiveness. So last week, the SBA finally came out with a new FAQ that explicitly states that you can apply for forgiveness as soon as you've spent 100% of your PPP funds, excuse me. So this is really great news. And especially for those borrowers who are anxious to get their PPP loans off their books. But this also raises a few questions about how this is actually going to work for borrowers that need to rely on safe harbors for salary or FTE loan reductions. So Ferdie, regarding the FTE headcounts, with the passage of the Flexibility Act and this updated long form application that we got, borrowers now have 3 different safe harbors that they can use to avoid a reduction in forgiveness based on FTE headcount. Can you give just a brief overview of those 3 safe harbors and tell us how they are incorporated into the long form application?
Sure, thanks, Drea. So although the updated long form forgiveness application is not quite as streamlined as the EASY forgiveness application, it does provide a more simplified approach for allowing borrowers to rely on the safe harbors for FTE headcount, as you mentioned. So on the new long form application, borrowers can simply check the box for one of those 3 safe harbors to avoid having to go through the complex calculations for determining FTEs for their covered period as compared to the prior baseline period. And so to give a general overview of the 3 safe harbors, the first safe harbor is more of a shortcut than a safe harbor, but it's available for borrowers who have not reduced the number of employees or the average paid hours of employees between January 1 of this year and the end of their covered period. So again, this safe harbor is really more of a shortcut that allows you to skip those detailed FTE calculations as long as you have not cut your headcount or average paid hours for employees since the beginning of the year. The second safe harbor is available for borrowers who, as Betsy mentioned, were unable to operate at the same level of business activity after February 15th of this year due to compliance with requirements established by HHS, the CDC or OSHA regarding sanitation, social distancing, or any other safety requirement related to COVID. And it's important to note that the SBA has confirmed in its most recent interim final rule that compliance with orders issued by state and local government are deemed to fall within that safe harbor. So, if you had to shut down your business due to any governmental order issued by Kate Brown, you would be included in that safe harbor and you could rely on that. And again, this is really a broad and blanket protection that allows borrowers to avoid any FTE-based reduction to their forgiveness amount. So it's really great news for borrowers. And last but not least, the third safe harbor allows borrowers to avoid a reduction in forgiveness if the borrower restores any decrease in FTE headcount that occurred between February 15th and April 26th by rehiring the employees that were laid off or furloughed in that period.
Yeah, so that's really helpful, Ferdie. And I've seen a couple of questions come in as you were talking specifically about whether or not state and local orders shutting down the economy would qualify. So that's really helpful guidance. We now know that the state and local orders will qualify the same as any federal order would. So that is really helpful information that we've gotten. So Ferdie, as a follow-up to the last safe harbor that you mentioned for rehiring employees, what is the new deadline for rehiring employees in order to be eligible for the FTE rehire safe harbor?
Yeah, so the new forgiveness application clarifies that the FTE headcount just needs to be restored as of the date on which the forgiveness application is submitted, or December 31st, whichever comes first, whichever is earlier. So as long as you restore your FTE headcount by rehiring those employees that were laid off by the date that you submit your forgiveness application, then you can avoid a reduction in forgiveness based on your FTE headcount. And so, this was a major change that, again, is really helpful for borrowers, particularly those that are, using an 8-week cover period and had planned to rely on that June 30th rehire date that was originally provided for in the CARES Act.
Yeah, so Ferdie, can you talk about, given the change in the deadline to rehire employees under the FTE rehire safe harbor, are there advantages for folks to go ahead and apply for forgiveness as soon as possible after they use up their PPP loan proceeds?
Yeah, that's a great question. And I think the major advantage with the new flexibility that's given is that a borrower really has more control now to ensure that they can avoid an FTE-based reduction in forgiveness. So, rather than waiting around until December 31st of this year to rehire employees to avoid that FTE reduction, borrowers can now restore their FTE headcount as soon as their funds have run out. And as long as you promptly apply for forgiveness after you've rehired those employees, then you can avoid a reduction in your forgivable amount. There's a lot of uncertainty right now for many businesses as COVID cases continue to rise in many states, and it really remains unclear if or when things will return to normal and whether businesses will be able to operate at full capacity. So the new rehire determination date kind of enables borrowers to avoid having to wait several months from now when they don't know what their business will look like several months from now, or maybe their business model will be completely different and they won't need as many employees. So it ultimately, if you've laid off or furloughed employees at some point between February 15th and April 26th of this year, absent specific circumstances, it probably makes more sense to apply for forgiveness as soon as the loan proceeds have been used up.
So switching gears just a little bit, one of the other ways that borrowers can have their loan forgiveness amount reduced is if they cut employee salaries by more than 25%. If you have a borrower who has cut employee salaries by more than 25%, can they rely on the safe harbor that you mentioned for COVID reduced business activity in order to avoid reduction in their forgiveness amount?
Yeah, unfortunately, no, they won't be able to rely on that one for reduced salaries. The safe harbor for reduced business activity, as I mentioned, is a broad protection for borrowers, but it is only available for FTE headcount reductions, and it is not available for borrowers who have reduced employee salaries by more than 25%. For those borrowers who have cut salaries by more than 25%, the way to get around that is you really need to restore those salaries to the pre-COVID levels by the date on which you apply for forgiveness to avoid that reduction.
So can you talk a little bit about, so if we have a borrower who has reduced salaries in excess of 25%, how does that factor into your loan forgiveness amount? Can you give us an example of that?
Sure. And before I jump into the example, I do want to remind everyone that the reductions to forgiveness based on those salary reductions in excess of 25% only apply for employees who did not make more than $100,000 on an annual basis at any point in 2019. So it's just important to keep that in mind if you're dealing with this type of situation. And so the way the salary reduction works in the forgiveness application is you take the annualized amount of the individual salary that was reduced in excess of 25%, and then prorate that amount for your covered period. So for example, if you had an employee who, for simplicity's sake, was making $100,000 on an annual basis in the beginning of the year, and then you cut their salary to $50,000 per year, cut it in half, you take the amount in excess of the 25% cut, so that's $25,000 here, and if you have an 8-week covered period, you multiply the $25,000 times 8, and then divide by 52, and that gives you that prorated amount. So your total reduction amount for that employee would be equal to $3,846. Now, on the other hand, if you're using a 24-week covered period, you would take the $25,000 number and multiply it by 24 and then divide by 52. And that gives you a reduction amount of $11,538, which is 3 times higher than the reduction amount for that 8-week covered period. And so, this just goes to show if you have reduced salaries for employees and are unable to restore those salaries, it may make more sense to utilize an 8-week covered period rather than a 24-week covered period to avoid an increased reduction in your forgiveness.
Okay, so, but what if you're in a situation where it's going to take you longer than 8 weeks to use your full PPP loan amount, but you apply for forgiveness in 10 or 12 weeks? At that point, do you still have to reduce your loan for the full 24-week covered period? So do you need to prorate the amount of reduction for salary reductions for the full 24 weeks, even if you apply for forgiveness before the 24 weeks is over?
Yes, that's the unfortunate thing. So if you are relying on that 24-week covered period and you've used up your PPP funds in, say, 12 weeks and you want to apply for forgiveness right away, you're still going to have to prorate that salary cut for the full 24 weeks. So that's another disadvantage if you cut salaries for relying on that 24-week covered period.
Thanks. So for borrowers who have had to reduce salaries for more than 25%, that 8-week versus 24-week covered period will actually matter to them.
Yeah, absolutely.
So I'm going to shift now to some of the answers that we have received in the past 2 weeks. The SBA has been busy. One of the questions that we've heard frequently following the adoption of the 24-week covered period is how that change would affect the caps on cash compensation that are paid to both employees and to owners. So Betsy, given the longer covered period of 24 weeks, has there been any change in the limit on forgivable cash compensation for employees?
Yeah, so as I'm sure most people remember, the program allows for forgiveness of cash compensation for each employee, and that includes salary, wages, tips, up to an annualized pay of $100,000. So for borrowers using an 8-week covered period, that equals $15,285 per employee. For borrowers using a 24-week covered period, the more recent IFRs and the updated forgiveness application did clarify that the cap on cash compensation is increased to $46,154 for each individual, and that's equal to 24 weeks of pay for an employee with annualized pay of $100,000.
And so is that the same? Is there a change in the cap for owner employees or owners' payments to owners if they choose a 24-week period versus the 8-week period?
Yeah, so there's actually an interesting difference between forgivable compensation for business owners versus employees for a 24-week covered period. So the limit on owner compensation eligible for forgiveness for a 24-week covered period is 2.5 months worth of 2019 net profits, capped at a maximum of $20,833. So this is different from the way you would calculate that for borrowers using an 8-week covered period, which caps owner compensation replacement at the same as W-2 employees at $15,385. And so the SBA has said that it's limiting owner compensation to 2.5 months to prevent an unintentional windfall to business owners that might be able to take advantage of the new safe harbors that Ferdie talked about, because the amount of their loan is capped at 2.5 months of payroll. If they, had an employee last year and don't now but qualify for a safe harbor, they don't want to then pay the business owner for their previous employee's salary as well. So they're just capping it at 2.5 months.
Thanks, Betsy. Yeah, so I think that guidance is consistent with Congress's stated goal of the PPP, which is to keep employees on payroll. So it's not necessarily surprising that employees and owners are going to be treated differently. But that's definitely a question that we've had come up. So that additional guidance is going to be really, really useful for folks going forward and figuring out how they're going to use their funds. So that concludes our overview portion of the updates from the last 2 weeks of what the SBA has been doing for the last little while. We have just about 15 minutes left, and we're gonna go ahead and start taking your questions here. We have received a number of questions ahead of the webinar, and we thank folks for submitting those. Gives us a little bit of an idea of what everyone is really focused on at this point. So I'm actually gonna start here with one of the questions that we received in the last couple of days. So please tell me the practical differences between using an 8-week versus a 24-week time period, especially if my 8-week expenses are a little bit shy of the loan. So this is a really great question. I think that we have a lot of folks who are in this situation where they maybe have been able to use a good portion of their loan proceeds, but they have just a little bit left. So now that we know that you don't have to wait until the end of your covered period in order to apply. And we also know that the same safe harbors apply as of your application date. There are fewer differences between the 24 and 8-week covered periods. And, you know, first, some of the similarities are that, so the minimum amount in both cases, whether you use a 24-week or 8-week covered period, the minimum amount that can be spent on payroll to get full forgiveness is 60%. And the rest must be spent on other qualifying expenses. That's the same regardless of which covered period you use. Both covered periods are going to be subject to the same FTE and salary reductions in loan forgiveness, and they can both take advantage of the same safe harbors as of the date of the application. One of the principal differences that I think of are the higher caps on compensation that Betsy just outlined regarding employees. So if you're having trouble using up your full amount, it may be that using a 24-week covered period and being able to pay your employees for a little bit longer is going to make sense for you, because you'll be able to use up more of your loan proceeds on forgivable purposes. But then the other major difference that I think of is what Ferdie was talking about a little bit ago with respect to if you actually have salary reductions in excess of 25%. If you use a 24-week covered period and you have salary reductions that you need to calculate into your forgiveness amount, your forgiveness is going to be reduced by a higher dollar amount than it would be if you use an 8-week covered period. For borrowers who have not reduced salaries, this may not be an issue, so it may not be a meaningful difference. But for borrowers who have reduced salaries, you just want to make sure that you run the calculations both ways before you decide which approach to take. So there are a lot more answers there, and I think that based on folks' individual circumstances, we should be able to get to a point where you can kind of figure out what makes the most sense for you. So I have a question here, Ferdie, about the 24-week covered period. If we are using the 24-week covered period, do all furloughed employees still need to be brought back by June 30th to receive full forgiveness? And what is the latest date that we can bring them back to work?
Right, yeah, so as I was discussing before, for restoring your FTE headcount, you just need to make sure those employees have returned to work by the date that you submit your loan forgiveness application. The June 30th date was the original date under the CARES Act to restore your headcount, but with the extension of the 24-week period, Congress changed that date to December 31st. And so that new guidance confirms that you just need to restore your headcount by the time you submit for forgiveness. And so the latest date that you can return them back to work under the Flexibility Act is December 31st of this year.
Great. Betsy, question for you about the easy application. Can I use the easy application if I elected to use an 8-week covered period?
Yeah, so you can use the easy application regardless of whether you're using 8-week or 24-week covered period. It doesn't matter the size of your loan or when you applied for or got your loan. The only thing is whether you fall into those 3 categories that I talked about earlier.
Great. So a question here, Ferdie, about the percentage of your loan proceeds that you have to spend on payroll costs. The question is, I spent more than 75% of my PPP loan on payroll costs. Will the amount that I spent on payroll still be eligible for forgiveness now that the required percentage is 60%, 40%?
Yes, so if you spent more than 60% of your loan proceeds on payroll, then you don't need to worry about a reduction in your forgivable amount based on the 60-40 ratio. So that 60% threshold is a minimum requirement. So that's just what you need to meet to avoid a reduction. And on the flip side of that, the 40% cap on non-payroll costs like rent, utilities, and mortgage interest, that is a hard cap. So if you spend more than 40% of your loan on non-payroll expenses, you will have a reduction in your forgivable amount.
Great. So we've started to get a lot of questions about the mechanics of applying for forgiveness. So Betsy, I'm going to give this one to you. Once a borrower fills out their forgiveness application, how do they submit it? Do they submit it to the SBA, to their lender? Like what's the process?
So it's through your lender, not the SBA. And so you have to really be in communication with your lender to see what they want to do for their process. So the applications that the SBA point out they contain the required information, but the lenders aren't required to use those. So some are going to be collecting your information in different ways, possibly through online portals, their own forms. So you really just want to be in communication with your lender about the process you're going to need to go through with them.
Yeah, and I would say that, we have quite a few borrowers at this point have finished their initial 8-week covered period, and they've decided they want to go ahead and try to apply for forgiveness. And they are reaching out to their lenders as we've recommended that they do, and are hearing that lenders are not yet accepting the forgiveness applications. And I think that is going to be a likely result for folks, that your lenders are still figuring out both the process that they're going to use, and they may also be waiting for some technical guidance from the SBA on how exactly they need to do everything. So I think it's just a situation where you want to stay in communication with your lender and be ready to submit your forgiveness application in whatever way they're asking you to do that when that becomes available. So about that though, Ferdie, how will this delay in lenders accepting forgiveness applications, how is that going to interact with the safe harbor dates for rehiring employees and restoring salaries?
Yeah, it's a great question. And I think it's an unfortunate situation for borrowers who have used up their PPP funds and are ready right now to submit their forgiveness application, and lenders just simply aren't ready yet. So I think that until the lender is ready to begin accepting those applications, you have to restore your FTE headcount on the date that you submit your application. So some borrowers might be in a situation where they have to wait 2 or 3 more weeks before they want to restore their FTE headcount to meet the date that they submit their forgiveness application.
Yeah, so it sounds like there may be a little bit of a moving target as lenders get their programs up and running, and especially for borrowers who are hoping to take advantage of these safe harbors that are specifically keyed to when you submit your forgiveness application. So I think that's going to be an important point. Related to that, Ferdie, I'm seeing a number of questions coming in saying, so once we have submitted our application, how long do we need to keep our FTE headcounts up? How long do we need to keep our salary levels up in order to continue to be eligible for forgiveness?
Yeah, that is a great question. And I know a lot of borrowers are thinking about that right now. And the answer is that currently borrowers do not have an affirmative obligation to keep employees on board or keep those salaries at the same level for any specific period of time. You know, whether or not the SBA will come out with additional guidance on this point remains to be seen. They might come out with some requirement at a later date that borrowers, you know, maintain that head count or the salary levels for X period of time. But at the moment, they just need to restore that FTE head count or those salary levels by the date that they submit their forgiveness application. And after that, the borrower can conduct their business as they see fit.
Yeah, and I would say as a follow-on to that question, that while I think borrowers want to act in good faith, you want to understand that the goal of this legislation and of this program has been to keep employees on the payroll. So I don't think it would be ever be a great idea to, cut your entire staff down significantly right after you apply. But with that said, we haven't seen any requirement to keep employees on the payroll for any specific period of time or to maintain salaries. And the trend at this point has been for the SBA to they're moving towards more borrower-friendly regulations. So I think we'd be surprised if we saw a specific requirement that would apply to borrowers at this point on that, but it's hard to say. Those things could happen. So we have just a few more minutes here. I want to talk a little bit about, we've had a couple of questions come in about this new exemption for COVID reduced business activity. And this is a big one because I think this is the situation where folks were not able to get their full-time employee numbers back up due to a reduction in business activity based on required closures. And the importance of that is not only that most borrowers will be able to use the easy application if they can qualify for that exemption. And even if you can't use the easy application, you are potentially eligible from an exemption from loan forgiveness reduction, even if you're using the long form application, if you can comply with this. So what we know about what you need to do, they're going to require you to submit copies of the regulations that are applicable to you, but your reduction in business activity could be due to either a direct or indirect effect of that regulation. So there's some flexibility there. And then the other piece that it looks like the SBA is looking for is an actual reduction in business activity. So, I think this is going to be true for a lot of folks across the board. And it looks like the type of information that they're going to ask for borrowers to submit to support this will be financial. So financial information of the borrower showing a reduction in business activity during that time. So let's see here. We are coming up against our time here. I just will close out with one more question here before we're done. So Betsy, this one is for you. So if I choose to use the 24-week covered period, but I apply for forgiveness after 10 weeks, do I have to prorate the $46,150 per employee for that 10-week period?
So as of now, you're not required to prorate that cap. So you could pay an employee up to that maximum of $46,154 in 10 weeks rather than 24 weeks. Keeping in mind what Ferdie said about how that applies to your 24-week covered period for reductions as well. So it's sort of the same principle. You don't have to prorate it, but they're not going to prorate your reduction either.
Okay, yeah, that's helpful. All right, so we are at the end of our time here, and as usual, we have quite a few questions in the queue. If we were not able to answer your question or answer a question that it was similar to your question, please feel free to reach out to one of us directly. Our contact information is available on Tonkon.com. It was also posted on the slide at the beginning. And we just thank everyone for joining us. We'll be doing another one of these before all of this is over. And we look forward to hearing back from you in connection with that. Thanks, everyone.